Thank you. My question is, do you have any suggestions in how to tackle a the two questions as a group?
Okay.
Manja, you're blacked out, mate. We can't see you.
Oh, sorry. Okay. Thanks. I'm not sure how I'm supposed to respond to that. Is it like, could I identify the issue for you?
Like, is it better to have perhaps in a group like a team leader, and then or somebody that is the main author of the answer, but like everybody adds the information?
Okay. So I would imagine that every single group will have its own unique dynamics. So it's likely the case that, there'll be somebody who might volunteer. I would assume there's always somebody who will emerge as the natural leader of any group. Leader, an informal leader, who would probably try to drive things along. And so that's for the purpose of getting the discussion going, getting people to provide their input and so on. So that's one. The other aspect, obviously, is in terms of doing the write-up of the answer itself. It's possible that somebody may volunteer to do that, or you may designate somebody. But for the purpose of getting somebody to write the answer, you'll be better off getting somebody who is quite confident about his or her own writing abilities. Because obviously, students have different levels of skills in terms of writing. So you need somebody who could probably be in a better position to actually write the answer. Now, apart from that, so more than the question of having the group dynamics where you end up discussing things, and then eventually having the output of somebody writing up the answer, you do need research. And that is probably an area where what you probably do is that before you start, well, you can have an informal discussion about what people think is the legal issue, but then at some point you really need to provide the legal research. So that's when you start examining what the potential legal issues are, what the relevant legal concepts might be, because then you need to be able to cite legal cases, because you're likely to be citing legal cases. You might need to cite some academic journals as well that expound on certain concepts that are needed to provide an answer that is based on research. So therefore, I've identified 3 activities that every single group member will be doing. One is to engage in the discussion informally, and you usually have a group, an informal group leader to drive things along. 2 is you need research. So everybody has to, I think, assist in providing research. And thirdly, you need somebody to do the writing of the answer itself. Obviously, once the answer has been written, it'll be good if the answer is then evaluated and examined by all the other group members, who could then provide their own suggestions or comments on how to improve the answer even more. So you have different roles. Now, in most group activities, it's always better sometimes, I think, to just focus on specialized tasks. Like, somebody really does the writing, somebody will really assist in terms of doing the research. But the writing, I think, it'll probably be good for somebody to just do the writing. But then everybody is free, of course, to come up with suggestions on how to improve the writing and to make sure that everybody's happy with the kind of answer that is being proffered by anyone. Did that answer your question, Kayla? Okay. Let me see the chat here. Okay, so from Jason, and I'm gonna read some of the chats here because these don't appear in the recording. So from Jason, Kayla, perhaps you could use Google Docs so you can all work on it and see the document at the same time. That's a fantastic suggestion, Jason. So for those who might be unfamiliar with Google Docs, it's an online document which is hosted by Google, and that's what we did, I think, with the MS online Excel file that we use to have the group composition. So that's a good way of doing it because everybody can easily look at what is there. And I think it's even possible to track any changes. So, everybody is aware of what's going on in the documents. Now, there's a comment here from Kathleen. It's a question. My question for the assignment is, are we supposed to address whether the parties have standing, just given that it is not exactly stipulated who Dick Rainier is? Okay, that's a very good question, Kathleen. The issue of standing is something that we assume exists. In fact, in the case of Dick Rainier, he does have standing because if you will observe, and we're looking at the group midterm assessment, this relates to question 1 where, according to the question, the ASIO has been engaged in eavesdropping on mobile and landline phone calls and intercepting work and personal emails within Australia. Now, we assume that Dick Rainier is an Australian, and so therefore, potentially, ASIO can be eavesdropping on his mobile and landline phone calls. So for that reason, he does have standing because his interests, his right to privacy, confidentiality of his communications, perhaps the possibility that some of his work emails might also be examined by ASIO. These would give him legal standing because it does affect his rights and interests and even expectations that his privacy would be expected. Now, having said that, do not touch on the issue of legal standing because that really isn't very important for the purpose of answering the questions or identifying the legal issues. Focus on the constitutional law aspects that pertain to any of the topics within the first 5 weeks. But that's a fair question, but don't focus on legal standing. We just assume that it exists. Other questions, comments? I actually had a question earlier from somebody. It was on an email, I think. If I could bring that up, the question was, okay, from Amy. So this is from Amy Brown, and this was asked in the forums. So she was saying, I was wondering if you could please clarify assignment 2 of the individual.
He said somewhere that it was you had to say the name a certain way as well. I don't know if everyone read that.
Sorry, my internet connection got cut off. So I may have missed something earlier. Did somebody say anything?
I asked about the word count.
Yeah, okay.
I'm reading in the chat here, so there's no concession. So it has to be between 500 and 550 words each question, doesn't it?
That's right. Yes.
Okay. That's all right.
Except that the footnotes are not counted as part of the word count.
Okay, then that's good.
So let me just go through the statement by Amy Brown, which was posted in the forum. So it says, I was wondering if you could please clarify assignment 2 of the individual task, as I am a little confused. Furthermore, I cannot locate the Queensland Anti-Terrorism Agency Act, Queensland. Is there a reason for that? Is that because it is non-existent? Also, what about the validity of it that you want us to advise on? Okay, let me just look that up. Okay, so in relation to question 2 of the individual midterm assessment, the Queensland Anti-Terrorism Agency Act, Queensland, is fictional. It doesn't really exist. So we just assume that that particular law has been passed. In fact, it is unnecessary, therefore, to examine the other content of that particular act. What is important, though, is that under that act, some Queensland state judges have been designated as members of the newly created Queensland Anti-Terrorism Agency, which is tasked with assisting the Queensland Police in investigating domestic terrorism. So if that were true, so in other words, if this had been, okay, so I'm not sure if I'm providing the answer here. Hopefully not. I don't think I am. But if this had been a federal law, okay, assuming that the Commonwealth Parliament passed a law known as the Anti-Terrorism Agency Act Commonwealth, where, so this is different. Let me clarify so people don't get confused, okay? I'm not going to be providing the answer for this particular question, but I'm going to be providing a contrast. Let me clarify, okay? So assuming that the question had been about the Commonwealth Parliament, and not Queensland Parliament, assuming that the Commonwealth Parliament passed a law known as the Anti-Terrorism Agency Act Commonwealth, okay? So assuming it's a different set of facts, okay? And under that Commonwealth law, there were some federal judges who were designated as members of a newly created federal anti-terrorism agency, which is tasked with assisting the federal police to investigate domestic terrorism. Okay, assuming those were the facts. Do you follow me so far? So it's not this question, assuming it were a Commonwealth legislation designating federal judges who would then assist federal police in investigating domestic terrorism. Had that been the question, okay, that there would have been a problem with the constitutionality of that law, because it would violate the doctrine propounded by the High Court in the Boilermakers case. There has been some discussion, I think, in weeks 4 and 5, because given the fact that there is partial separation of powers in Australia, the High Court has been very clear on two things. It will not tolerate the vesting of judicial power on non-Chapter 3 courts, so that's one. So the High Court will not tolerate or will not allow, under the Constitution, based on the concept of the separation of powers, it will not tolerate the vesting of judicial powers on non-Chapter 3 courts. So an example would be the Administrative Appeals Tribunal. Wait, hang on. Is that part of the test? Okay, so it would be unconstitutional, for example, for the Commonwealth Parliament to vest judicial power on a non-Chapter 3 court. So an example would be an agency of the executive. So an agency of the executive cannot have judicial powers because that will violate the separation of powers under the Boilermakers case. So that's one aspect. The other aspect is because of the separation of powers, as clearly propounded in the Boilermakers case, the High Court also will not allow the vesting of non-judicial powers on Chapter 3 courts in general. So, for example, if a non-judicial function, such as the investigation of domestic terrorism, if such a function were to be imposed on Chapter 3 courts, that would be unconstitutional. That would run afoul of the Boilermakers case, except to the extent of what is known as the persona designata doctrine, which you will later on see. Okay, so there is that rule in the Commonwealth Parliament and at the level of the Commonwealth. So are we clear so far? Boilermakers case, that applies only to the Commonwealth setup. Now, the question in question 2 relates to the vesting. Okay, I'm not going to define what has been vested, but the one in question 2 relates to a state law, which seems to designate some state judges to undertake what might be considered to be non-judicial functions. I don't know if those are the judicial functions or not, so that's something you have to examine. So is the investigation of domestic terrorism, does that comprise a judicial function? Okay, so that's question 1. If it were to be a non-judicial function, would it then violate, the question of separation of powers? But you need to note, this is at the state level. The Boilermakers case does not apply. So I think that's as far as I can say something about that particular question, because otherwise I'll end up providing the answer. So it's just a caution to you that the Boilermakers case does not apply. Okay, because a lot of students do get confused. They assume that because of the Boilermakers case, therefore, that principle is applicable to the states. The answer is no. The answer is no, because as you will see in the notes, the separation of powers generally does not exist in the states. There is no separation of powers in the states. That's as far as I can go in terms of providing an answer to the question.
So could I ask you, and you don't have to answer, could I ask you please, if this anti-terrorism agency would be similar to QCAT?
Yeah. Would it be similar to QCAT? I'm not even sure if it really matters. Because if you examine QCAT is quite different, because on the one hand, it's a judicial court. That's why it's called the Queensland Civil Tribunal. So it does examine judicial questions, so it has judicial functions. But it also is an administrative tribunal. So you have a tribunal that is handling both judicial functions and non-judicial functions. You will notice, right? In the QCAT. And that's quite common in the states. You can't have that at the federal level, but that is obviously possible, legally permissible in the states. And so there goes your answer.
Okay, I'll leave it at that.
We have to leave it at that. Okay, what about when you consider the principle in cable? Okay. Okay. Good question. Now, should we be going into that at this point, or it might be too, we might be discussing it a bit too much ahead. Okay, let me just touch on this. Are you happy for me to discuss this? Although this is going to come out, I think, in week 5. That question from Monique. So Monique's point was, and this is very valid, what about when you consider the principles in cable? I may be a little confused about how cable should be interpreted regarding the separation of powers extending to the states. So that isn't covered yet in weeks 3 and 4. I think it's covered in week 5. So should I try to address that? It can get confusing for those who haven't read up to that chapter yet. Okay. So in general, as we said, okay, so pardon for those who haven't, who haven't studied the chapters for the succeeding weeks, because I used to have students complaining that we ended up discussing topics that were not meant to be taken up. But given that this is a drop-in session, it's not a tutorial, so I think it's fair for me to have a go at a discussion of these topics. And I think I've seen about 4 or 5 of you saying it's okay for me to discuss it. Okay. So as I said, in general, I said that the separation of powers does not exist in the states. Unlike in the Commonwealth, there is a partial separation of powers. We call it partial because, in fact, the Parliament and the Executive are fused, in the sense that the Prime Minister and the Cabinet belong to the Parliament, and therefore, they actually control, to a great extent, the legislative agenda. Unlike in the US, the President isn't part, in the United States, the US President or the Executive isn't part of the US legislation. In the Westminster system of government, the Prime Minister and the Cabinet belong to the Parliament as well. So you have a fusion of the executive and parliamentary powers to an extent. And so therefore, there's only a partial separation of powers at the level of the Commonwealth. At the level of the states, though, what we need to remember is that upon federation, the colonies continued to retain the powers that they had prior to the federation, except those powers that were then devolved to the Commonwealth. Now, prior to federation, the colonies had the same powers as the UK. Now, if you will remember, in the UK system, there is such a thing as parliamentary supremacy. And the idea about parliamentary supremacy is that the courts are powerless to strike down any law passed by the parliament, by the UK parliament, as being unconstitutional. Mainly because in the UK there is no constitution. In the same manner, in New Zealand, New Zealand doesn't have a constitution that exists as the supreme law of the land or the fundamental law of the land like Australia does. So both in the UK and in New Zealand, the courts do not have the power to strike down a law passed by the parliament as being invalid or unlawful or unconstitutional, because there is no written constitution. And which is why there is such a thing as parliamentary supremacy, because the parliament is supreme. So the idea then is that prior to the federation, the colonies carried the same powers as the Westminster UK government, where you had parliamentary supremacy. So therefore, upon federation, given the idea of parliamentary supremacy, the state parliaments therefore have parliamentary supremacy. And for this reason, in general, and I want to clarify in general, and we're going to address the question of Monique in a short while. So in general, state courts do not have the power to invalidate a legislation passed by a state parliament. So are we clear so far there? We're clear, in general. So in general, state courts do not have the power to invalidate a law that is passed by a state parliament. However, based on the Cable Doctrine, there is such a thing as you will hear later on, the autochthonous doctrine. So there is what is known as the autochthonous doctrine. What this means is that state courts, in fact, are actually part of the integrated Commonwealth or federal judicial system. So the state Supreme Courts are actually part of the Australian Commonwealth judicial system, because decisions of the state Supreme Courts eventually can be heard by a federal court on appeal or on a petition for certiorari. Do you follow so far? So although state courts in general belong to the states, and in fact state courts are creations of the states. So in other words, state parliaments can do what it wishes or what they wish with their state courts, because the state courts are creations of the state parliaments. In contrast, the High Court is not a creation of the Commonwealth Parliament. The High Court was created by the Australian Commonwealth Constitution. Can you see the contrast? So the Commonwealth Parliament cannot do away with the High Court, because that has been created by the Australian Commonwealth Constitution. The state Supreme Courts, on the other hand, are creations of the state parliaments by a state law. So in theory, I'm saying in theory, it is actually possible in theory for state parliaments to disband state Supreme Courts, in theory. Now I say in theory because under the autochthonous doctrine, the High Court will not allow that, because there has got to be a judicial organ within the states which has the mechanism for certain subject matters to be heard by a state court, which can then be elevated to the federal courts. So to repeat, although state courts are creations of the states, they actually also are part of the Commonwealth or the federal judicial system. Okay, and so what the High Court has said is that whilst it is true that state parliaments have general control over what can happen at the level of state courts, and it's even possible for state judges or even state Supreme Court judges to be given non-judicial powers. And I'm not sure if I'm answering the midterm assessment now. Hopefully not. So I'm just discussing the concepts, okay? So while it is true that because there is no separation of powers at the level of the states, the first rule is that it is impermissible for state parliaments actually to disband state Supreme Courts, such that there will no longer be a state court that becomes part of the federal judicial system. So the High Court won't allow that. Are we clear so far? So there's that limitation. The second limitation is that although it is true that it is possible for the state parliaments to vest non-judicial powers on their state judges, because separation of powers does not exist in the states. However, under the Cable Doctrine and the principle of the autochthonous doctrine, the High Court also will not tolerate instances where the state judges become instruments or instrumentalities or tools of the state parliament. So in other words, if the state judges just become, are subject to the control of the state parliament, therefore bringing into question the independence of the judiciary, that will no longer be tolerated, because that impacts in the end on the integrity of the Australian judicial system, the common federal system. Okay, was that clear? Yes.
Were you saying, all right, so the Supreme Court in Queensland is a Chapter 3 court?
It is not a Chapter 3 court, no.
No? So, but still, are you saying that all of the courts in Queensland have to observe there has to be observed a separation of power? So that the
no, that's what I said. So let me discuss on 2 points first. So one, state courts are not Chapter 3 courts, because as I said, they are creations of the state parliaments. A Chapter 3 court is a court that is constituted under Chapter 3 of the Australian Constitution. So the High Court is a Chapter 3 court because it is created by the Australian Constitution. But also under Chapter 3, the Australian Commonwealth Parliament has the power to create courts, which are then Chapter 3 courts. So when it creates federal courts, you have the security of tenure for the judges in federal courts. So are we clear? So you can only consider a court to be a Chapter 3 court when it is constituted according to the provisions of Chapter 3 of the Australian Commonwealth Constitution. And because state courts were not created under Chapter 3, but under state legislation, they cannot be Chapter 3 courts. Clear so far? Okay, now, however, as we said, because of the autochthonous doctrine, even if these state courts are not Chapter 3 courts, because of the autochthonous doctrine, some of them are actually considered to be part of the Australian federal judicial system still. They are not Chapter 3 courts, but they are treated to be integral parts of the Australian federal judicial system. Those are two different things. Okay, now for that reason, it is possible for state judges to be vested with non-judicial powers. That's fine at the level of the states, but there are two restrictions, as I mentioned earlier. One is that there has always to be, at the level of states, a state court that has to be part of the federal judicial system. And two, it would be impermissible for state judges to become mere instruments or tools either of the state parliament or of the state executive. Okay, was that clear?
Okay, so in question 2, we are not necessarily talking about Supreme Court judges, but just judges in general.
Queensland state judges.
Which could include Supreme Court judges?
It could include Supreme Court state judges.
Okay.
So actually, it doesn't really matter whether they're Supreme Court state judges or whether they're magistrate judges. It shouldn't really matter. So the basic issue there. No, okay, I can't go into detail because I'll end up discussing the legal issue. But I think I provided enough, information on that without giving away the answer. I think because it was, we were just talking about theory here. Very good questions.
Thank you, Manjo.
Other questions? I think it would really be helpful if you discuss this in groups, because there'll be a lot of ideas that will come out, and there'll be some who will know more about this topic, others will know more about these topics, and when you end up having these discussions, you'll be more informed because of the viewpoints of the different students. Okay, anything else? So we're good. Do we have to get the answer right in the quiz to obtain the 10% mark? From Jacqueline, you need to be able to answer correctly all the 10 questions for you to get 10%. So if you only get 9 correct answers, you only get 9% of the final grade, because every single correct answer of a quiz comprises 1% of the final grade. Now, the question is, do you need to pass all the online quizzes? I mean, get them right? The answer is no. But it does become helpful later on, because I don't think the online quizzes are that difficult, are they? They probably are not, I think.
Play on words, I think.
Yeah, that's right. So I tend to phrase them to be a bit confusing. Yeah, but if you're just careful, you should get the answers right. That's right, Anthony. Okay, so from Kathleen, let me just address this. I'm a bit confused about your post in the assessment forum about not answering. Okay, whether Parliament has power to pass the legislation, but we are supposed to go into whether the executive has the power to make the legislation. Okay, 2 points. I did not want you to have to identify what head of power the Commonwealth Parliament used in order to pass a specific legislation, because that is a topic covered, I think, in week 7 and 8. You don't have to. We just assume. Okay, it may not be very apparent to you yet what the point is, but so let me just address that briefly. We will later on realize that based on the Australian Commonwealth Constitution, the Commonwealth Parliament the powers of the Commonwealth Parliament are actually limited only to those that are provided in the Australian Commonwealth Constitution. All the other powers belong to the states. So in other words, if the Commonwealth Constitution does not provide the Commonwealth Parliament's ability to pass a legislation on that specific topic, then the Commonwealth Parliament is powerless to pass a law in relation to that. So for example, in relation to crimes at the level of the states, or in relation to education, the Commonwealth Parliament does not have the power to pass laws in relation to those subjects. It is the states which do. Okay, so because of that, there are only limited subjects on which the Commonwealth Parliament can legislate on. If the Commonwealth Parliament passes a law in which it cannot cite a head of power, for example, under Section 51 of the Australian Commonwealth Constitution, that would be unconstitutional, because the assumption is all the other subjects which have not been vested exclusively to the Commonwealth Parliament belong to the states. So in general, the states can legislate on anything, in general. In fact, the Commonwealth, except those which are exclusive to the Commonwealth Parliament, such as coinage and currency, belong to the Commonwealth Parliament. So it is for this reason that you don't have to identify the head of power on which the Commonwealth Parliament passes a legislation. You don't have to. We just assume that the Commonwealth Parliament has the power to do that. So is that clear? Because that's a totally different topic. That's going to be for week 7 and 8. Now, there was a point here by Kathleen when she said, we are supposed to go into whether the executive has the power to make the legislation. Let's clarify again, okay? It is not a question of the executive having the power to pass laws, because in general, the executive does not have the power to pass a legislation. Only the Commonwealth Parliament has the power. Okay, there's such a thing as subordinate legislation, though. There are instances when the Commonwealth Parliament will delegate certain lawmaking powers to the executive. And that's in relation to the power of the executive, for example, to pass regulations or bylaws that are according to a primary legislation or primary enactment passed by the Commonwealth Parliament. Now, so I think what Catherine is saying is not so much about the power of the executive to pass legislation, it's simply about the executive power per se. Okay, that's different. So the question is, some of these questions actually raise questions about the extent of the executive power. It's about the extent of the executive power. Okay.
Yeah, Manjo, I got a question.
Yes, Anthony.
In regards to prerogative powers, like if it's not stipulated in under Section 51, the certain rights to make prerogative powers, how far does that extend? Does that extend to everything, or is there certain limitations on that?
Okay, so let's clarify first about what the executive powers, the sources of the executive powers. Let's begin with that. So there are three sources of executive powers. One is based on the Constitution, where the Constitution clearly says that the executive, through the Queen, has the power to execute and ensure the maintenance of the Constitution of the Commonwealth. So that is a source of the executive power. That's according to the Constitution. At the same time, as I said, it is possible for the Commonwealth Parliament to delegate certain powers to the executive through what is known as subordinate legislation. So in that case, the power that has been delegated to the executive again becomes a source of executive power. So for example, when it comes to the regulations that are passed by the Minister of Immigration and Border Protection pertaining to migration, that is a result of the Migration Act of 1958 Commonwealth, where the Commonwealth Parliament delegated or vested in the Minister for Immigration and Border Protection certain powers pertaining to immigration. So clear so far? So we have the Constitution, we have delegated powers from the Commonwealth Parliament. There is a third source of power, and that is what is known as the prerogatives or discretionary powers. Now, prerogatives or discretionary powers are actually what are known as powers that inhere in the executive as recognized by the common law courts. So historically, the courts have recognized that the executive, even in the absence of even if it is not written in the Constitution, like in the UK, there is no written Constitution, right? So the question is, because there is no written Constitution in the UK, does it mean that the monarch or the executive, let's say the Prime Minister and his cabinet, does it mean that they don't have any executive power because there is no written Constitution? The answer is no, because historically, we will recall in the UK, for example, that the monarch was absolute. The monarch not only had the power over the realm to, execute the laws, the monarch actually had the power to pass certain laws until, in 1658, because of the Glorious Revolution, it was King George recognized the power of the Commonwealth Parliament the power of the UK Parliament to pass laws. But notwithstanding that historical phase, it was still understood that there were certain powers that belonged to the executive. For example, the power to enter into treaties, the power to pardon prisoners, the power to negotiate with heads of state, or the power of coinage. So even if it is not written in a constitution because it does not exist, even if it has not been invested in the executive by the parliament, there are certain prerogative powers that belong to the executive, even in the absence of that authorization by the Constitution or by the UK Parliament. So these are known as the prerogatives or discretionary powers. They inhere. Now, your question was, to what extent can the executive powers, the prerogative powers of the executive be exercised, which may be inconsistent with the powers of the Commonwealth Parliament? That's a fair question, right? In general, the rule is that if the Commonwealth Parliament passes legislation on areas that typically would have belonged to the executive prerogative powers, for as long as the statement of the Commonwealth Parliament is expressed to limit the powers of the executive in that regard, then that applies. The power of the Commonwealth Parliament prevails over the prerogative powers of the executive. Okay, but I'm not going to cite the case because it's part of the online quiz for quiz 2. I'm not going to cite the case, but if you read the book and my notes, you will know the answer there. So I'm not going to cite the case because, as I said, it's part of quiz 2. But the rule is the courts will not make an implicit assumption that the Commonwealth Parliament deliberately tried to curtail the extent of the exercise of the executive prerogative powers. Okay, so clear. Now, however, I would think that it is an open question whether or not the Commonwealth Parliament can, in fact, really constrict or limit the exercise of certain prerogative powers. For example, the power to pardon prisoners, or the power to enter into trade relation, to enter into diplomacy with other states. I think it is difficult. I don't think it has come across before the High Court, but I would find it personally. I would find it unlikely that the Commonwealth Parliament can curtail, for example, the power of the Prime Minister and his cabinet as to when they can give, for example, pardons to prisoners, or let's say honors to the Queen's how do you call them, the Queen's the awardees every year. Those are the honorific awards, those titles. I'm not sure the Commonwealth Parliament has the power to do that, because I would argue that there are certain prerogative powers that really exclusively belong to the executive. That would be an example, or the power to determine which countries or states the executive, the Australian state should deal with. I'm not sure if the Commonwealth Parliament can pass a law saying that the Australian, Prime Minister and his cabinet cannot enter into relations, let's say, with Iran, because to me that is something that's exclusively belonging to the executive. But that's an open question. I don't have the answer for that. I don't think that has been tested in the High Court. So in general, therefore, in answer to your question, Anthony, in general, the Commonwealth Parliament has the power to limit the exercise of executive prerogative powers in certain areas, such as migration, but it has to be explicitly stated by the Commonwealth Parliament. Now, but there are other prerogative powers which I think exclusively belong to the executive, that I think it would not be proper for the Commonwealth Parliament to deal with them. And the example I gave was the matter of pardoning prisoners or entering into relations with other states. Okay. So from Jason, yes. Who was that?
Yeah, sorry. Yeah, just when you say expressly stated, are we talking about through the mechanisms to make law? Is that where you're heading there?
Legislation itself.
Yep.
So,
okay.
For example, it's difficult for me to give the example, because that's covered in online quiz 2, and it's actually part of the midterm assessment. But say the power to, let's say, the power to declare war. Okay, that's an example of a prerogative power belonging to the executive. It is the executive that determines whether or not Australia should go to war. Now, the mechanisms, however, because the defense of the Commonwealth is also in one of the heads of power of the Australian Commonwealth Parliament. So to an extent, therefore, the Commonwealth Parliament can pass a law providing certain guidelines as to the conduct of war. And to that extent, there will be constraints on the Commonwealth prerogative power, to an extent. the perfect example would have been migration, but again, I can't discuss that because that's part of the online quiz too. Yeah. Other questions? There's a question. So was that okay, Anthony?
Yeah. I know where you're going with that. That's fine.
Okay,
Thanks.
thank you. Now, from Jason, does that mean that states could reintroduce capital punishment? Okay. Now, let's begin with the idea that in the first place, the Australian Commonwealth Constitution does not have a Bill of Rights, unlike in the US. So, for example, in the US Bill of Rights, they have what is known as, it would be unconstitutional to have cruel and unusual punishment. So let's not use capital punishment because I think it's possible to do that. Let's just say the use of torture, because that's, I think, cruel and unusual punishment.
And,
so, Jason, yes.
Sorry to interrupt. I sort of meant that from the point of view that, you know, I recall growing up when I was a boy that, you know, Australia has gotten rid of the death penalty, for example.
Yes.
But if that's really down to a state level, theoretically, a state could reintroduce it. Now, it'd be wildly controversial, but it wouldn't be up for the Parliament to say, or the Commonwealth, no, you cannot do that.
That's right.
Yeah.
That's true. That's right. So it is actually possible for the state, for the states to reintroduce the death penalty or the capital punishment. The bigger question, though, is assuming that the state parliament reintroduced the death penalty or the capital punishment. Could that be brought before a state court to question its validity? And the answer to that question is actually part of the midterm assessment. I'm not going to tell you what the legal issue is, but it is the same thing. Are there certain questions that courts cannot deal with? So I can't go beyond that because that's part of the midterm assessment.
Angela,
you want to say something?
Sorry. Yeah, I was just going to say, if the state, for example, the states decided to bring back capital punishment, and the federal government didn't want it, the federal government could then just pass a law to say that capital punishment's illegal, isn't it? And then wouldn't that override any state law? Because doesn't the Commonwealth law override the state law?
No, it doesn't work that way because no, it doesn't work that way because the power of the Commonwealth Parliament is restricted only to those that are provided in the Australian Commonwealth Constitution. And there's nothing in the Australian Commonwealth Constitution which provides that the Commonwealth Parliament has the power concerning state crimes and punishment of state crimes. So for that reason, the identification of what constitutes a crime or the definition of a crime and the punishment of a crime or for a crime, these are state matters. And the Commonwealth Parliament has no power at all. It would be unconstitutional for the Commonwealth Parliament to legislate in relation to what constitutes state crimes. It can in relation to federal crimes, but certainly not in relation to state crimes. It is for the states to do that. Now, so therefore, can the Commonwealth Parliament pass a law that would restrict the power of the states to define what constitutes crimes and what the punishments therefore should be? The answer would be no.
So the only laws that the Commonwealth can pass are the ones that the Constitution allows for it to pass. Is that right?
Yes.
Aha. Okay. Right.
So that's the main limitation, which is why it must, every time the Commonwealth Parliament passes a law, you must be able to identify the head of power in the Australian Commonwealth Constitution. Because if it cannot identify the head of power, then the Commonwealth Parliament does not have the power to pass a law on that subject, because everything else belongs to the state. So that's the framework there. So the state parliaments can pass any law, anything pertaining to the states. I mean, not to other states or not to the Commonwealth, but anything that happens, for example, in Queensland, in theory, the Queensland Parliament can pass a law. The only limitation is if it violates the separation of powers. The only limitation would be if it goes against implied rights and freedoms under the Constitution, or if it goes against, for example, principles of representative democracy or responsible government. So those are just the main constraints, or if they belong exclusively to the Commonwealth Parliament, as stated in the Australian Commonwealth Constitution. So unlike the state parliaments, which can legislate anything within its territorial sphere, within its state, the Commonwealth Parliament can only legislate in relation to those subjects that are provided in the Commonwealth Constitution.
So, Manjo, just to take that one step further then.
Yes.
So,
but as a warning, you know, we're moving too much ahead, okay? Because this is discussed in week 7 and 8. But again, it's fair to discuss this because we're assuming that, you know, the Commonwealth Parliament passes certain laws. So it'll be good for us to understand how it's able to do it in the first place. I'm just making that clarifications because I don't want other students to complain why we're discussing this now.
Yes, I think it'll fit in though. To take it one step further then, if the Commonwealth wanted to intervene, well, going through section 28 of the 128 of the Constitution, to go to a referendum to change the Constitution, then they could introduce something into the Constitution to override what the states are doing. Is that correct?
Well, yeah, if there is a referendum and there's an amendment to the Constitution, which then provides further powers to the Commonwealth Parliament on a subject that would have exclusively belonged to the states, the answer is fine. Yeah. But one thing you need to know though, and again, we're jumping too far ahead, is that the states actually have the power to delegate to the Commonwealth Parliament the power to legislate on a subject that would have belonged to the states. So the states can do that. And that's why you will notice that that the Commonwealth Parliament has the power to tax, and the states are not. When in fact, the states could impose income taxes. But you will notice that, so the power to tax, to impose income taxes actually belongs to both the states and the Commonwealth Parliament. Okay? So the Commonwealth Constitution recognizes the power of the Australian Commonwealth Parliament to impose taxes. And because we said the Australian states can do anything they like, it is understood that the Australian states also have the power to tax. But the question is, how come that today income taxes are only imposed by the Commonwealth Parliament under an income tax law of the federal government? And that is because the states in the 1940s surrendered the power to tax to the Commonwealth Parliament. And they, in that legislation, they recognized that it would now be exclusively to the Commonwealth Parliament to impose income taxes in return for certain governments and financial benefits that the federal government guaranteed to the states. So there is that mechanism, but we will explore this a bit later. I think in week 9. Was employment law referred by the states to the Commonwealth? There are certain areas pertaining to employment law as well as company law as well. And that is why we have what is known as a Commonwealth company law, although there is still company law at the level. I'm not sure if there's still employment law at the level of the states though. I'm not sure, so it's not my area. So that's difficult to answer, Monique. But there is that possible referral of certain heads of power which should have exclusively belonged to the states, which the states can then give to the Commonwealth Parliament. Okay, anything else? 8:13. We're good? Yeah, cross-vesting, that's right. It's called cross-vesting. Thank you, Gordon. Well done. So you've read far ahead, Gordon. Very good.
That was from previous courses that I've done.
Very good. Thank you. Okay, so I think this is a good time for us to end the tutorial. We've been at it for about an hour. I hope the session was helpful. And thanks for joining tonight's session. And all the best in your assessments. I wish I could do more, but you wouldn't be enjoying doing the assessments if I gave you the answer. I think it's going to be fun for you to think about, Okay then. So everyone, thanks for joining tonight's session, and I'll see you on Thursday. Bye. Good night.